Good afternoon. This is a recording of a talk I gave at several universities in the US in spring 2024. The talk was well received and I was encouraged to record it for more people to benefit from it. The topic of the lecture is the European perspective on ESG shareholder activism. For some background, I am Timo Fest. As of October 2024, I am the new professor of corporate and capital markets law at FAU Erlangen-Nuremberg. Currently, my research focuses on corporations and capital markets law, and over the next 40 minutes, I will give you an insight on ESG shareholder activism in the EU, and particularly cases of recent shareholder campaigns on the subject of sustainability. To set the scene, in the Paris Climate Agreement of 2015, among other commitments, more than 150 countries pledged to become climate neutral by mid-century. This self-commitment is unattainable without the involvement of major industrial companies. To make progress on this, the EU Commission in 2019 introduced the Green Deal, an action plan requiring companies based in the EU to become carbon neutral by 2050 through a range of legislative acts. As I'm sure you are aware, nearly all European countries have significantly underperformed on their annual climate targets as of today. Consequently, the pressure for transformation, particularly on energy-intensive industrial companies, will continue to increase. Beyond the political sphere, significant pressure is now being exerted by a different group of stakeholders, activist investors. One of their core demands is for management bodies, who are not legally obliged already, to develop and publish climate transformation plans. To the extent that companies already have such plans, it is not uncommon for investors to consider these insufficiently ambitious. They may then engage with the company, presenting their strategy for a carbon-neutral transformation in informal discussions with management. Such conversations can put considerable pressure on the management, depending on the investor's influence. If management categorically rejects the investor's demands, they risk the investors publicly criticizing the company's strategy, which can lead to a significant market reaction. To avoid such pressure, the management of Dutch Shell plc opted to present its climate transformation plan to shareholders for voting at the 2021 annual general meeting. Shell's shareholders approved the plan with nearly 90% majority. Such votes, known as Say on Climate, remain rare to this day. Consequently, investors globally are exploring ways to compel the boards of carbon majors to present their transformation strategies for voting at AGMs. Let us now examine various approaches of shareholder campaigns across jurisdictions. Starting with familiar US law, specifically the shareholder proposal rule, and then moving on to discuss sustainable shareholder activism in the EU. Since 1942, shareholders in the USA have the right under Rule 14a(8) of Section 240 of the Securities Exchange Act of 1934 to submit proposals to companies registered with the SEC. The aim of this process is for companies to include these proposals in their proxy materials to be voted on in shareholders' meetings. The thematic focus of shareholder proposals has shifted several times over the past decades. Proposals aimed at improving corporate governance dominated discussions until the turn of the millennium. Since then, shareholders shifted their focus towards environmental issues. In the US, the highest profile shareholder proposal on sustainability comes from ExxonMobil in 2017. Exxon has regularly been the target of environmental shareholders. This stems from the 1989 incident where the Exxon Valdez ran aground off the coast of Alaska, triggering one of the largest maritime environmental disasters. A legal consequence of this catastrophe, relevant to our topic, are the so-called Valdez Principles. These are 10 principles of corporate governance and reporting that companies should adhere to. Despite these, Exxon continued to provide limited information on the environmental impact of its business activities for decades. This was something a Church of England investment vehicle thought to change through a shareholder proposal around 2016. Specifically, the board of directors was to be urged to disclose the impacts of climate change on Exxon's business in more detail. To achieve this, Exxon was to conduct stress tests annually, measuring how its oil assets would be affected by climate change regulations and new technologies. Before I report the outcome of the campaign to you, let us take a look at the prerequisites for shareholder proposals under Rule 14a-8. First of all, not every shareholder is entitled to submit a shareholder proposal. Eligibility is limited to those who can demonstrate that they have continuously held shares of the company for a period of 1 to 3 years, depending on the market value of shareholdings. The proposal must be accompanied by a supporting statement. This statement must not only provide a rationale for the proposal, but also include evidence of share ownership and a declaration of intent to hold the required amount of securities throughout the date of the next shareholders' meeting. The proposal, along with any accompanying statement, must be submitted a reasonable time before the company begins to print and send its proxy materials, typically no less than 120 calendar days. While institutional investors can easily prove their eligibility and comply with the procedural requirements, the company may nonetheless refrain from including the shareholder proposal in its proxy materials if one of the exclusion criteria listed in Rule 14a-8, paragraph 1, number 1 to 13 applies. Particularly significant for sustainable shareholder activism is number 7, known as the ordinary business exception. Under this provision, the company may reject a shareholder proposal if it deals with a matter relating to the company's ordinary business operations. This exclusion criterion is based on the principle that the applicable corporate law, typically the DGCL, assigns matters of ordinary business management to the board of directors rather than the general meeting of shareholders. Consequently, the subject matter of the shareholder proposal must involve policy issues that transcend day-to-day business. If this is the case, a second hurdle needs to be considered: the prohibition of micromanagement. The proposed shareholder resolution must not be an overly detailed set of instructions to the board of directors, but should serve as a general guideline. These general guidelines allow shareholders a degree of influence on management activities. This is an important ability afforded to shareholders under US law, which we should keep in mind when contrasting the EU perspective. If the company chooses to exclude a proposal, it must submit that proposal along with its reasoning for rejection to the SEC. While the SEC does not have the legal power to override an exclusion, the Commission publishes an opinion on the permissibility of the proposal in question. While this opinion is non-binding, companies overwhelmingly adhere to the Commission's finding. Let's return to Exxon and the Church of England. The board included the shareholder proposal in the proxy materials, but recommended a no vote to shareholders. Typically, activist proposals do not garner majority support among shareholders. However, this was not the case with Exxon. Due to the influence of proxy advisors, the fund managed to organize a majority of approximately 62% of the votes. Such shareholder resolutions are non-binding decisions, meaning the board is under no legal obligation to implement the proposal. Nevertheless, the shareholder resolution holds considerable factual significance, as disregarding it regularly leads to a significant reputational damage for the board of directors and the company. With an understanding of the US law and its implementation, let's turn to the EU perspective. So far, few management boards have voluntarily developed climate transformation plans, and even fewer allowed shareholders to vote on these. Although almost every plan that has been presented for a vote over the last years was approved with overwhelming support, the number of companies voluntarily presenting such plans to shareholders continues to decline. Consequently, some environmentally focused shareholders are seeking ways to initiate votes on issues related to carbon neutrality transformation themselves. The EU does not have fully harmonized company law among member states. However, since the 1970s, the EU has issued numerous directives in an effort to align certain aspects of company law. For background, these directives themselves do not form the letter of the law in a given member state, but create an obligation for the country to reshape its national law to align with the provision of the directive. In regard to shareholder activism, the most relevant directive is 2007 number 36, broadly covering the rights of shareholders in listed companies. Within this directive, Article 6 covers the right to put items on the agenda of a shareholder meeting. The requirements of this right are similar to those of US Rule 14a-8 in numerous aspects. As in the US, the right to request an addition to the agenda is not available to every shareholder. Instead, the petitioner, acting individually or collectively, must hold a minimum stake in the company as set by the governing law of the member state. The ownership threshold in Germany, for example, of 5% of the company's nominal share capital or a stake of 500,000 euros is significantly higher than what is required under Rule 14a-8, where the maximum hurdle is a market value of $25,000. Unlike US law, the European Directive does not impose a minimum ownership duration. The additional procedural requirements are insignificant hurdles. The proposal must be submitted in writing, include a justification, and be submitted to the company prior to a deadline set by the member state. The legal starting point for a campaign is governed by Article 6 of the EU Directive 2007 number 36. As the directive is only a legal guideline, we must look at its implementation within member states to better understand shareholder activism in Europe and contrast this to the US approach. Of those few environmental shareholder campaigns that have been started in Europe to date, activists have focused on German car manufacturers, especially Volkswagen. As Volkswagen is governed by German law, we must understand the approach taken by the German legislature in implementing the directive. Since activist investors can meet the procedural requirements to propose a resolution, the most significant hurdle concerns the subject matter of the resolution to be voted on. There is consensus that shareholders can only initiate votes on matters within their specific powers. Before I delve into this exclusion criterion with an example, we need to become familiar with the corporate governance of German stock corporations. In contrast to the Delaware one-tier board system, every German stock corporation must have 3 bodies. The first body is the management board. Its main task is to manage the company and conduct its business, acting under its own responsibility. The second body is the supervisory board. Its main duty is to appoint and monitor the management board. The third body is the general meeting of shareholders. Its power is limited to 2 areas. Firstly, matters that arise annually, such as deciding on the use of net income. And secondly, fundamental matters such as amending the Articles of Association. Understanding this division of responsibilities is critical for sustainable shareholder activism. Many tasks related to transforming the company to carbon neutrality fall under the remit of the management board. As such, they are reserved matters for the management board, meaning shareholders cannot issue binding instructions on these. Consequently, sustainable shareholder activism in Germany is limited to matters within the narrow powers of shareholders. The legal demarcation between the powers of shareholders and those of the management board can be difficult in practice. Illustrative of this is a supplemental request that reached the management board of Volkswagen in the spring of 2022. Its goal, inspired by the successful campaign against Exxon, was to require the management board to disclose all lobbying activities of the group companies regarding climate change annually. To establish this obligation, shareholders proposed an amendment to the Articles of Association of Volkswagen. While amending the Articles of Association is undoubtedly a matter within the remits of shareholders, this alone is not sufficient to ensure the admissibility of a proposal. The proposed resolution must not violate the German Stock Corporation Act. At this point, a fundamental principle of the Act becomes significant, namely the so-called Articles of Association strictness. This principle is based on the idea that shares should be standardized capital market products. Therefore, we have to distinguish between 2 categories of provisions in the Articles of Association. A provision can either deviate from the Act or expand its rules. A deviation from the Act within the Articles of Association is allowed only where the Act itself permits such a deviation. Meanwhile, an expansion to the provisions of the Act is generally permitted unless the Act exhaustively regulates the area in question. Where a proposal constitutes a deviation is to be answered by referring to the Act. Due to the European Corporate Social Responsibility Directive, large German stock corporations have been obligated since the financial year 2017 to expand their annual reports with non-financial statements. These consist of a description of the company's business model and information on how it impacts certain aspects of sustainability, such as the environment. The level of detail is determined by a materiality principle. This principle only determines the minimum content of the statement, but does not limit the management board from including additional details. In the Volkswagen case, the proposed request for more detailed reporting on lobbying activities by shareholders does not alter the minimum content of non-financial statements and therefore does not constitute a deviation from the law. Instead, the provision seeks to expand the reporting regime at Volkswagen beyond what is required under the Act. As additions are generally permitted unless the Act exhaustively regulates the area in question, it needs to be clarified which area of the Act the proposed provision pertains to. Just as a reminder on the case, a reporting and disclosure obligation for the management board is to be introduced. Therefore, the primary focus is on providing shareholders and other investors with more information, specifically regarding the lobbying activities of Volkswagen's group companies. These pieces of information are not subject to any confidentiality obligation. On the contrary, to the extent that shareholders inquire about lobbying activities during the shareholders' meeting, the management board must respond truthfully. Consequently, the information sought in the additional report would already be known at least to the attending shareholders. Therefore, the permissibility of the shareholder proposal is argued as follows. If the management board is required to truthfully respond to a question about lobbying activities, it can also be compelled through the Articles of Association to disclose the same information in a report. Following this reasoning, we could conclude that the proposal constitutes a permissible addition to the Articles of Association as it expands the shareholders' right to ask questions. Taking a closer look at the proposal itself reveals an issue with this reasoning. It states the petitioners are investors who want to use their shareholder rights to influence companies to adopt more climate-friendly corporate policies. And it goes on. In this context, they demand greater transparency regarding the climate-related lobbying activities of their investee companies. The wording reveals that the shareholders' goal is not limited to obtaining information, but to steer Volkswagen's lobbying activities. The enhanced disclosure obligation is merely a means to this end. But what indicates the steering effect? In the sustainability report from 2021, the Volkswagen Management Board set a goal for itself to operate in a climate-friendly and environmentally conscious manner. This would suggest that lobbying activities are primarily concerned with promoting climate and environmental protection, such as memberships in organizations like Greenpeace, etc. However, to believe Volkswagen's lobbying is actually confined to such engagements would be naive. It is well known that associations of car manufacturers work to ensure that new regulatory requirements are favorable to their objectives. Towards the public, these activities are presented in a way that suggests the status quo is highly climate-friendly and environmentally conscious. Per the shareholder provision, if Volkswagen contributes to such associations, the management board would have to report this. The resulting contradiction with the sustainability report would significantly damage Volkswagen's carefully crafted image as a green company, and therefore, to avert this reputational damage, the management board would have to cease all such lobbying activities. Fundamentally, however, the decision on which lobbying activities to continue or discontinue is a matter for the management board. Can a shareholder's proposal govern this area through an amendment to the Articles of Association? The answer is no. The German Stock Corporation Act conclusively regulates management. The task of running the company is solely assigned to the management board, and this allocation is safeguarded in relation to the other corporate bodies, in particular limiting shareholder influence on management. Shareholders can only act if requested by the management board. In other words, shareholders cannot take unprompted action. If the management board does not request the decision, it has no standing. This limitation of shareholder influence in management matters is justified in the context of the German Stock Corporation Act. Whereas shareholder proposals under US law are limited to non-binding resolutions that management may voluntarily implement, this limitation does not exist under the German Stock Corporation Act. Shareholder resolutions are not limited to non-binding statements, but can compel the management board to implement the results of shareholder votes. Consequently, management matters are only exceptionally presented to shareholders for voting. In the case of Volkswagen, it was not the management board that asked shareholders whether a reporting obligation regarding lobbying activities should be introduced. Rather, the initiative came from a minority activist shareholder. When presented with the case, the higher regional court ruled that the reporting proposal constituted more than a reporting obligation, but rather an attempt to unlawfully interfere in management activities. Therefore, it was deemed inadmissible. Another example concerns climate transformation plans, which have been mentioned several times already. A large number of boards has drafted and published climate transformation plans already. However, practically none of these have allowed for shareholder input. There is a growing demand from numerous international investors for boards of large industrial companies to solicit non-binding opinions on existing climate transformation plans. The issue arises whether a vote on climate transformation plans can only be initiated by the board or also by shareholders through a supplemental request. In Germany, most scholars would agree such a right of shareholders does not currently exist. There is consensus on the starting point, namely, drafting climate transformation plans is a management task with the consequence that the management board alone is responsible. There is also consensus that shareholders can neither prescribe guidelines that the management board must follow when drafting such a plan, nor pass any resolution that compels management to alter an existing plan. But do shareholders have the ability to issue non-binding opinions, even without the board's approval? The German Stock Corporation Act is not clear in this respect. Section 119, paragraph 2 of this Act can be interpreted in two ways. First, shareholders may issue non-binding opinions on any matter, including management reserved matters, as these do not technically compel management to act. Second, without a request from the management board, the shareholders can neither decide nor express their non-binding opinion on any management matters. The majority in the legal community supports the latter conclusion, as legally non-binding resolutions still exert significant factual pressure on the management board. As we have established, shareholders in Germany currently have limited opportunities to express themselves on environmental and climate protection issues. In contrast to the US, where the legal framework in place enables broader shareholder engagement. Therefore, voices calling for more shareholder power in Europe are growing louder. Let's look at a suggestion that has already been made to the German legislature. Specifically, it is proposed to expand the powers of shareholders to include a so-called say on ESG. This would enable shareholders to provide commentary on all sustainability issues related to the activities of the company. Minority shareholders should be able to initiate a vote on non-binding ESG resolutions, even without the consent of the management board. The proponents of the legislative change hope for an alignment of shareholder groups. In their opinion, voting at AGMs has the potential to overcome the conflict of interest between primarily profit-oriented shareholders and primarily environmentally conscious shareholders. I'm not particularly confident. As powerful anti-ESG movement has already formed in the US, which rejects any departure from shareholder value thinking in favor of climate and environmental protection. In my opinion, the vehemence with which the group operates does not suggest an alignment of shareholder groups is likely, but rather that confrontation on an open stage will take place. The second argument in favor of the proposal stems from a comparison of legal systems. While in the US, shareholder proposals to introduce reporting obligations are permissible, this is not the case in Germany, as we have seen. So one could say US law raises the expectation of internationally operating investors to vote on climate transformation plans. German law disappoints this expectation. However, globally, the legal situation in Germany is the rule rather than the exception. This is illustrated by looking at the more than 1,400 companies in the MSCI World Index. Of these, only 10 have adopted a shareholder resolution on climate transformation plans in 2021 and 2020. Why is this the case? We cannot answer with certainty, but I have a suspicion. When legislating on corporate law, lawmakers in all countries are faced with the question of which body to assign which powers. In a comparison of legal systems, you will find that the answers are overwhelmingly similar. Differences often only exist in the details. The root cause of this is the cross-jurisdictionally recognized principle of the so-called body adequacy. It stipulates that decisions should be made by the body that is best suited for it, based on its composition, function, and procedural rules. So let's take a closer look at the general meeting. Only shareholders belong to this body. The homogeneity of the participants means that shareholders in most legal systems may only opine on matters that directly affect their interests. Examples include the voluntary dissolution of the company and the use of the net income. To be distinguished are matters that also concern shareholder interests but primarily affect other areas, such as climate and the environment. Since climate matters do not directly fall under the category of shareholders' matters, it would not be reasonable for shareholders to determine these issues. In this respect, the introduction of a say on climate, giving shareholders wider powers, would not be a system-compliant development of the shareholders' mandate, but a departure from the dominant organizing principle of company law. With that, I have reached the end of my presentation. Thank you for your time and attention.